Welcome to this week's edition of It's Chaile Time. This is my new look. I've decided that from now on I'm wearing these hats. Some people say, especially my wife, it makes me look very intelligent and clever. Anyway, so this week we will be doing a case law review. We're actually doing or studying a bit an arbitration award from the CCMA, and we will be dealing with the issue of probation. You'll be surprised how often a probation or the lack thereof in the workplace can be a snare to an employer, because some employers still have this mindset that if you put somebody on probation and thereafter the conclusion of the probationary period, maybe the person did not perform, that the person can simply be dismissed without following a fair procedure or so forth, because they say the contract of employment is only confirmed once the probation had been successfully completed. So in this case, what's quite interesting, and we're going to focus on two elements in this case. This case is Ntabi Singh Malebane versus LNP attorneys. Just get to my right spot here. In this case, there are two elements we're going to focus on. To what extent does the contract of employment that does not have a probationary provision inside of it trump a letter of offer where it actually does state that the first 3 months will be on probation? And secondly, to what extent do we need to follow some kind of procedure as far as the audi alteram partem rule are concerned? Now, for those of you who don't know, that really just means an employee must be given a fair opportunity to be heard before you dismiss a person. Okay, so, and that is what a fair procedure in South African labor legislation is basically founded on. Audi alteram partem, giving an opportunity to an employee to make a case, to make representations before a decision is made to dismiss. Is it necessary? What do you think? Do you think it is necessary that there must be a hearing before you dismiss an employee during the probationary period? But anyway, so in this case, this employee was an attorney appointed by a law firm. There's been issues, or allegedly there's been issues with not being a corporate fit. Now, as you know, in terms of dismissals, in terms of the LRA, you basically get 3 grounds. 3. The one is misconduct, and therefore you have a Schedule 8.4 procedure if you want to dismiss an employee like that. You have operational requirements, which is typically your retrenchments, and there you have Section 189 and or Section 189 capital A of the Labour Relations Act. And then you have incapacity. Now, incapacity's got 2 elements to it. The one is poor performance. The other one is predominantly ill health, but you also get other aspects of incapacity like legal incapacity and so forth. But that's not relevant to the discussion today. So we'll be talking about poor performance. Now, when you talk about an employee not being an organizational fit, we're talking about the elements of poor performance. Now, the poor performance process is really explained in Schedule 8, subsection 9 and 10 of the Labour Relations Act. That's basically where you will find the procedure and the process. So, but in this case, the employer seemingly had a problem with her not being an organizational fit, in that she's a very dominant kind of person. She's been accused of not being a team player. And so there was 3 interventions by the CEO where she had meetings and engagements with the employee. But now it's debatable in terms of what the nature of the discussions was. There's no evidence. There's no minutes. There's no notice to attend a hearing or anything. The employer or the respondent in this case are simply of the view that these were probationary meetings, even though there's no written evidence to that extent. But interesting is the applicant, the employee, saying, no, those won't poor performance meetings or probationary meetings. Those were merely meetings to see if I am settling in or so. So there's immediately a contradiction in terms of what the purpose of these meetings was. Okay. So at the end of the day, the employer at some point did mention to her that, she's not an organizational fit, she's a bit dominant. I think that was like in meeting 2 or 3 or so, which she's obviously disputing because there's no evidence. And then the employer did a interesting thing. The employer then sent her a letter to say, you are now dismissed, they are obviously disputing the existence of a dismissal, but that your employment will be terminated. We are not going to confirm your indefinite or permanent employment. That's a bit more accurately put. And this is now what gave rise to this dispute. In the mind of the applicant, the employee, she was dismissed. In the mind of the respondent, no, because you were in probation and your appointment, your full-time appointment was simply not confirmed. But there's a bit of a catch to this case. The employee's main argument really was twofold. Secondly, that there was no procedure followed when she was dismissed. Okay, we'll get there now. But firstly, nowhere in her contract of employment does it actually provide for a probationary period. Now, we all know that typically, most commonly in a contract of employment, you will have some form of probationary period or provision inside there. But in this case, it was not in there. There was, however, initially a letter of offer signed, which stated that the first 3 months the employee will be on probation. So, can we now agree that, or should we agree that the employee was indeed on probation based on the letter of offer? Or can we say that she was not on probation because it was not in the contract of employment? Let's just see quickly what the contract of employment did state. Number one, in point 2.2, her employment will continue for an indefinite period. So this is now the employer highlighting certain provisions in her contract that alludes to the fact that she's already permanently employed and there's no probation. So number one, her employment will continue for an indefinite period. Number two, her employment will terminate on the grounds of retirement when she reaches age 65. So at least she's guaranteed of employment. When I say guaranteed, unless she gets dismissed for reasons acceptable in law, up to the age of 65. Number three, termination of employment will be on 1 calendar month notice. Number four, the agreement is the whole agreement between the parties. And number five, no addition to or variation, cancellation of this agreement has effect unless in writing and signed by the parties. So was she on probation, yes or no? In this case, the commissioner was compelled to believe and to agree with the employee that the contract cannot be read with the letter of offer and that the employee was actually not on probation. But interesting, the commissioner, as far as procedure is concerned, reminded us of section 191.5a and section 188.1 of the Labour Relations Act. Let me just read it quickly. Section 188, subsection 1 states, a dismissal that is not automatically unfair is unfair if the employer fails to prove that the reason for dismissal is for a fair reason, that the dismissal was effected in accordance with a fair procedure. It doesn't say here that people on probation, the employer don't have to follow a fair procedure. So even though this employee, according to the commissioner, was not on probation, he said, but even if she was on probation, you cannot dismiss an employee without following a fair procedure. And this is where the confusion sometimes comes in. Because let me just read to you quickly the procedure for probation in terms of Schedule 8 of the Labour Relations Act. Okay? Or not probation, poor performance. Because remember, ultimately the reason for the dismissal was poor performance. Okay? So we know that in terms of probation, you must still follow the procedure. But was the procedure followed? Because according to the employer, they had 3 meetings with her. It's debatable what was discussed. But must you call a hearing? And this is a point I'm trying to make now, because a lot of companies feel that you don't really need to call an employee into a disciplinary hearing, because that's a Schedule 8.4 procedure when you want to dismiss for misconduct. Must you call somebody for a hearing if you dismiss for poor performance? It's a bit of a contentious issue because of Schedule 8 subsection 9, which gives you the guidelines for poor performance. Okay? Any person determining whether a dismissal for poor work performance is unfair should consider the following things: whether or not the employee failed to meet a performance standard, and if the employee did not meet the required performance standard, whether or not the employee was aware or could reasonably be expected to have been aware of the required performance standard, the employee was given a fair opportunity to meet the required performance standard, and dismissal was an appropriate sanction for not meeting the required performance standard. Now, this is interesting because nowhere here does it actually explicitly mention the word disciplinary hearing. Schedule 8.4 does mention all the steps of a fair procedure in terms of a misconduct dismissal, but it doesn't say so here. Now, also interesting is section 191.5a of the LRA actually puts the onus on the employer to show that the dismissal was fair. So in terms of section 188 and 191, the onus is on the employer to prove, number 2, that a fair procedure was followed. Now, interesting of this section 8 subsection, or schedule 8 subsection 9 of the process in terms of a poor work performance, it says here that when a decision maker determines whether dismissal is unfair, now that determination should still operate within the audi alteram partem rule. An employee should still be given an opportunity to make representations. And there you also have common law rights, like for instance a right to make representations, and in terms of Schedule 8, for instance, the right to have interpreter or somebody to represent you. The questions you're going to ask is not the same as with a misconduct. A misconduct is really do a guilt finding. Does the evidence on the balance of probability substantiate the employee is guilty, and then justify whether dismissal is reasonable or not? In a poor performance process, you're going to have to apply your mind to whether there are performance standards in the workplace. Is the employee aware of the performance standards? Did the employee fail or met the required performance standards? Did the employee get a reasonable opportunity to actually meet the required performance standards? So the way you conduct that hearing is a little bit different, but it is still based on audi alteram partem. So in a nutshell, what we learn here today is, number 1, make sure that if you want to have employees on a probationary period, that it's actually stipulating so in the contract of employment. It seems like the commissioners are not going to accept if you have a letter of appointment or a letter of offer which explains or provides for a probationary period, but it's not in the contract, because it seems like the contract trumps the letter of offer, especially those provisions in the contract that states that this is the full agreement between the parties. And secondly, if you want to dismiss somebody for poor performance, you still need to follow the audi alteram partem rule. You must still call a person to a hearing and allow them to make representations. Now, yes, there's the conversation about how formal must a hearing like that be. Well, in principle, a hearing does not have to be overly formal, but that's a conversation for another day. The point is, you must give an employee an opportunity to make representations, and also for people on probation. You cannot just arbitrarily and unilaterally dismiss a person like that. Yes, the reasons for dismissing a person under probation can be less compelling, but nevertheless, in terms of section 188, subsection 1, the employer must still prove they did follow a fair procedure. Employees on probation is not excluded. So there's the answer. If an employee is on probation, you must still follow a disciplinary inquiry when you want to dismiss an employee like that. That's this week for Chaile Time, and I hope you've enjoyed it. Please do subscribe and like, and I will see you next week. Thank you.